Estate planning attorney Jeff Fouts here. Some people say to themselves, well, I'm going to avoid probate altogether because my house is joint with right of survivorship. Joint with right of survivorship. Well, let's talk about that. Firstly, you need to double check to make sure it really is joint with right of survivorship, because in about 10% of the cases that I look at, the deed is not in reality joint with right of survivorship, even though people think it is, and it's not going to avoid probate. But let's assume for the moment that yours actually is joint with right of survivorship and that it will avoid probate. So the husband dies and the wife's alive. When the husband dies, does it avoid probate? Yes, it avoids probate for that one particular asset. That's all we're talking about. So good. Now the wife has the asset, right? Right. But there's a problem. The problem is she can't refinance or she can't sell it to downsize. Why not? Because the house has a dead man's name on it. So it has her name on it and it has the dead spouse's name on it. And so now she's got to take a couple of steps to clean that up. It's not as complicated as probate, but she still must take a few steps because that asset has something called clouded title. And now they must clear that title up. Okay, good. So let's assume they do that. Good. Now, then the wife dies. Is it going to avoid probate then? The answer is no. It most certainly 100% will not avoid probate at all. It'll only avoid probate between the first one and the second one. So when the second one dies, we may have a difficulty in that when the wife dies, it may have two dead people's name on it, the husband and the wife. If that's the case, we're going to have a two-step process to clear the title up to get the dead husband's name off even before we can really finish up the probate with the wife. That's what we call a two-step probate. But now sometimes wives say to themselves, well, I'm going to fix this. You know, I'm going to avoid probate and I'm going to avoid it by titling it to my children. Well, that's a very, very bad thing to do. Even though it appears to be efficient, it appears like the cheapest way to do it, there's lots of reasons that is a very bad move. And let's talk about it. Number one is you open up your asset to your children's mishaps, their divorce, auto accidents, bankruptcy, divorce. All of those things make your property accessible in case there's a lawsuit. And you may say, well, yeah, but it's my property. No, it's not. It is not your property if you name your child on it. It is also their property. And so it doesn't matter whether it's your property, wink, wink, nod, nod. It is not, now it isn't that. It is their property, subject to their problems. But let's imagine you have perfect children and nothing ever happens and then you die. Well, they go to sell the house. Well, I've got bad news for you. When they go to sell the house, they're going to have to pay tens of thousands of dollars probably in capital gains tax. Why is that? The reason is pretty simple. Because you gave it to them during life rather than at death through an estate plan, they are going to lose something very valuable. And what they lose is called the step up in cost basis. Step up in cost basis. And so that is going to cost them lots and lots of money. So what you thought was going to be simple, I'll just put it in my kid's name. I've heard it's a great way to do nursing home planning and keep it protected from the nursing home. That's a very bad idea. And so it'll end up being expensive, etc. So anyway, what you don't know can hurt you. If we could ever help you in any way, review your estate plan, just let us know. Thank you.